Morning, Your Honor. May it please the Court, my name is Gregory Connor, and I represent the Commonwealth. I was the attorney in the trial court in this matter. On January 19th of 2010, the Commonwealth satisfied the statute of limitations and provided notice to the defendant when he had been charged with the count of armed robbery out of the Stoughton District Court. On January 20th of the year 2000, a man believed to be the defendant had walked into a Randolph Savings Bank in Stoughton at approximately 11:30 a.m. This man was said to be wearing a tan knit cap, sunglasses, and a scarf covering his face. He demanded money, was given money in excess of $5,000, and the witnesses saw a man fitting the same description leaving a white sedan that was subsequently found in an adjoining parking lot. Inside that car was a white tan knit cap matching the cap of the description of the assailant. In 2002, that cap was processed by the State Crime Lab, and scrapings were recovered from that cap. In 2003, the Stoughton police received information that they could now prepare this scraping for DNA analysis. However, that cap stayed and those scrapings stayed with the Stoughton police until 2007.
Let me see if I understand your position. The statute of limitations is 10 years?
Yes, Your Honor.
And when do you start to count?
You start to count
10 years from the date of the crime?
You should, I believe, under Rule 46A, you would start the day after of the crime.
All right. The crime was January 20th?
January 20th of the year 2000.
2000. So you say January 21st, 2010?
Yes, Your Honor.
That's the 10-year period?
Yes, Your Honor.
And
the indictment was May of 2010?
Yes, Your Honor.
And the complaint was, the application for the complaint was filed on January 19th, 2010?
The application was filed and the complaint issued on January 19th.
On the 19th.
So the Stoughton police kept it till 2007, and then the lab kept it from 2007 until?
2010, Your Honor. Where analysis.
When was the analysis done?
The Stoughton police.
When did you find out about it? I guess I should ask that.
Yes, Your Honor. The Stoughton police received a fax on January 15th, 2010 that the analysis was completed. The officer didn't see that fax until the 16th, which was a Friday. They went to speak to the defendant, who was in custody at the time on something completely different, and that following Monday, the 18th, was Martin Luther King Day. So the next available date to apply for the complaint was the 19th, January 2010.
Your argument, though, rests on the claim that the word indictment does not mean indictment. It means complaint and indictment.
Yes, Your Honor. That is adopted from what a judge in Essex County did on the Commonwealth versus Ackerman case. And not to misstate it, it's that if you read 277, Section 79, in conjunction with 63, the statute of limitations, that statute 63 should apply equally to complaints and indictments.
Doesn't that make sense if you think of complaints remaining as complaints? In other words, complaints are governed by this statute of limitations, but if it's a crime, as here, that has to be an indictment, the word indictment means indictment.
Yes, Your Honor. However, the complaint can still be a mechanism to prosecute someone in the Superior Court. For instance, if they waive indictment.
Yes, but he didn't.
Yes, correct, Your Honor. However, the statute, if you read 79, it applies, we would suggest that it applies to both. And while he did not, he had the opportunity to waive indictment. In addition, there's the potential of the bind-over hearing, in which the same papers, the complaint would be, after a bind-over hearing, transported to the Superior Court.
Do we have any legislative history as to Section 79 as to whether it means anything else than that the forms that we provide apply to complaints as well as to indictments, that it was meant to have this substantive consequence, which is that it will affect the statute of limitations?
No, Your Honor. Point blank, no. As far as the legislative history to 79, no. I believe that in the analysis that was used in that Essex case, the judge believed that to not do this would lead to potentially an absurd result, that there would be no statute of limitations in the district court.
No, it would I mean, that's why one could read it as referring to complaints when they remain complaints, not complaints that morph into indictments.
But that wouldn't help.
Wouldn't help here, but
Yes, but,
Go ahead.
Your Honor, the end result would be that if not to apply 79's reading to 63, that there would be an open-ended window of no statute of limitations for the district court. I agree, but you have to understand, it's our position that where a complaint can result in a superior court prosecution, either by waiver, potential bind-over hearings, that has the same weight as an indictment, consequently. I believe it was the DeGaulier case, which is cited in the response brief by the Commonwealth, which shows that a person can be sentenced on that complaint in superior court.
So you would then substitute the word complaint for indictment everywhere that it appears in Section 63, even where the legislature has said, with respect to specific crimes, any indictment or complaint found and filed after a certain period of time is sufficient.
Yes, Your Honor. This court has had to interpret legislative history and had to act upon ambiguities in drafting in the past. In the George case, what should have been a period was a semicolon. And as a result of that semicolon, one could read that the statute of limitations only applied to the 6-year felonies that were found and filed, and not to any of the other crimes that were enumerated in that statute.
But doesn't that make the word complaint, when it is used in Section 63, totally superfluous? And isn't that something we try not to do?
Yes, Your Honor. However, when a statute lends itself to a reading that could be absurd, as stated in George,
Why is this absurd? I mean, if in fact people had done things a little quicker, there would be time for an indictment.
Yes, Your Honor. I believe what the absurd reading would potentially result in is that there's no statute of limitations for the district court.
Not if you read it as saying it applies to complaints as complaints.
Well, Your Honor, I disagree, because as a result of this, there's no if you disregard the Dixon analysis in the Note 20, which says that 63 should be applied equally to complaints as it does to indictments.
Of course, that wasn't really analysis, that was dicta.
Yes, Your Honor, it was.
A case within the jurisdiction of the district court, wasn't it?
Not as Note 20 refers to it. However, I agree that the analysis that is adopted from Dixon is in the Northern Telecom case and also in the Vouchers case, which are district court cases.
That's what I'm thinking of, yeah.
Yes.
I mean, I think your argument rests not on Section 79 for your business that misdemeanors wouldn't be able to have a statute of limitations. Doesn't that come from the fact that the catch-all provision in Section 63, because it refers only to indictments, would then provide no limitations period for misdemeanors brought by complaint? But then it seems to me, if that's the case, and it's just the catch-all provision, the 6-year catch-all provision, that you could take care of the absurdity issue by just saying, as to that catch-all provision, they meant complaint as well as indictment, and not read indictment throughout 63 as meaning indictment and complaint, which would then, if you did that, render all the uses of complaint superfluous. You could fix the problem, in other words, by a solution other than the one that you propose.
Yes, Your Honor, the potential is that the solution could be fixed with the legislature. However, the issue is right now that as the statute reads, there is this ambiguity that if you have no statute of limitations for the district court underneath the catch-all provisions, does that not apply equally to the other provisions that don't have the sentence, that don't have the word complaint in the sentence?
Why?
Well, Your Honor, I would suggest that it would create somewhat of a strange anomaly where all of a sudden one sentence is supposed to be inferred to have complaint in it, and the preceding sentence doesn't.
So let's take Chapter 265, You have Section 63 reads, an indictment for an offense set forth in Section 17, 18, 19, 21 of 265 may be found or filed within 10 years. Are any of those offenses within the jurisdiction of the district court?
No, Your Honor. The armed robbery, assault, intent to rob, unarmed robbery, no, they are not.
None of them are in there. And then the paragraph just, or the sentence just above that, offenses set forth in Sections 22 and 24 of 265. Are any of those within the jurisdiction of the district court?
No, Your Honor. Rape, assault, rape, human trafficking, no. I guess my comment to that is that then you have a situation in the last sentence where trafficking has the same statute of limitations as assault and battery. Yet there's no mechanism to ensure that there's a statute of limitations for assault and battery.
Well, surely we would have to read Section 79 into Section 63, right?
That's the Commonwealth's contention, Your Honor, yes.
Your contention is that we should read it into every one of those clauses, even where the legislature has gone out of its way to indicate both indictment and complaint.
Yes, Your Honor.
But is there any statutory history? Are these places where they've said indictment or complaint somehow added after the fact? Or any statutory history with respect to why they chose to word those sections differently?
Not that I understand, Your Honor. In 2006, the amendment was passed that added the word complaint into the statute, which provided for the indecent A and B and the basically the sexual crimes against children. While the legislative history is somewhat blank on that, the question then I think that the Commonwealth was faced with was, do we still have a situation where a defendant could be charged in the district court with a felony, say trafficking, and then there's no statutory, there's no statute of limitations, or worse yet, or I should say more analogous, assault and battery dangerous weapon, where there's concurrent jurisdiction between the two. Is there no jurisdiction, or is there no statute of limitations as a result of that last sentence not having the word complaint in it?
Anything else, Counsel?
If there's nothing further, Your Honor, the Commonwealth will rest in its brief. Thank you.
Good morning, Patrick Troy on behalf of Mr. Perella, and with me is Attorney Dennis Toomey. My brother is correct. There are a series of issues in the statute that he's concerned about and the Commonwealth is concerned about, but I believe those issues are not solvable in this venue. They're solvable at the legislature. There are defects in the statute, or confusion.
Well, surely, would you agree that there must be a statute of limitations for offenses filed in the district court?
I do, Judge.
And the statute of limitations section is 63?
It is, Judge.
And it doesn't really refer to matters in the district court.
It doesn't, Judge, specifically. I believe you're referring to the last clause that references indictment in the catch-all. It doesn't reference complaint.
And so why shouldn't we apply 79, which says that the provisions of this chapter shall apply as well to complaints as to indictments?
Judge, I did not see the relationship between Section 79 at the time this motion was filed, nor do I see it today. I think 79 applies to forms in the content of the pleadings as they may be on a complaint or an indictment, and not to apply to each section.
Well, it is curious. It says the provisions of this chapter and the forms hereto shall apply. Suggest two different things.
And, Judge, I think that's where appropriate. And I think the statute that we're dealing with specifically lists an indictment is necessary for the crime that Mr. Perella is charged with. It doesn't say complaint, where other sections of the statute reference complaint. And I believe it's fair to assume that if the terms are both used in the same section of the same chapter and they're not included for the robbery statute, which specifically says a defendant may be indicted within 10 years of the time of offense.
So if the crime were in the concurrent jurisdiction of the district and superior court, you wouldn't be here. You wouldn't be making this argument. If it was let's say a crime of assault and battery by means of a dangerous weapon, if he was charged the day before the statute of limitations expired or ran in the district court and then was subsequently indicted for the same crime, it's within the concurrent jurisdiction of the district and superior court, you would not be making this argument.
Would the same argument apply to a 6-year statute of limitations if the district court is going to retain jurisdiction over that case?
No. I'm trying to figure out if your argument depends upon the fact that only the superior court has jurisdiction over this particular case.
Correct, Judge.
Is that what your argument depends on?
In this set of facts, Judge, yes, it does, because this is only a charge that can be indicted and has no jurisdiction in district court.
Well, what if the Commonwealth had reduced the charge to larceny from the person and then indicted him for larceny from the person?
I believe larceny from the person, Judge, would be within the 6-year catch-all, and we'd be well beyond that window, wouldn't we? For
Okay,
a 10-year
But
indictment?
let's say you had a 10-year statute of limitations. Could you indict for a lesser included offense that was within the concurrent jurisdiction of the district court?
I think if it complies with the statute, you could do that.
You could do that.
If it complies with the statute, Judge, but you're talking about, if I'm understanding correctly, concurrent jurisdiction of nothing to do with this case, but hypothetically.
Yes.
If a crime existed where a 10-year statute of limitations was in concurrent jurisdiction with district court or superior court.
That's right.
And it starts with a complaint, and within the statute. I think this is,
So-
and then.
If the statute
beyond the
affords that it can
statute, the
begin with a
indictment
complaint, then I
comes.
think it satisfies the statute, that it can begin with a complaint, whether it stays in district court or subsequently gets indicted.
So it's not the fact of indictment that's not the cutoff here. It's that a criminal proceeding over which the district court had jurisdiction started, and it was later transferred to the superior court. So long as it was timely commenced in the district court, that saves the case for the Commonwealth.
In your hypothetical, it may do that, Judge, yes. I don't think that's what we have in this particular case. I think we have a statute that's clear. An indictment is necessary for a crime that has an exclusive jurisdiction in superior court and nothing to do with district court. Mr. Perella, in this case, by way of history, was also charged in district court with, I believe, a motor vehicle offense, which ultimately was not indicted because it fell within the 6-year catch-all and could not be. What was left in the Commonwealth's view was we have our only chance to indict Mr. Perella is by way of a quick complaint in district court, which this court is aware is distinctly different from a grand jury proceeding. It could be argued that in many district courts, it's just a rubber stamp involved with getting a complaint to issue to beat the clock or stop the clock.
And it doesn't make any difference that he would get credit for time served from the day the complaint issued and he was held from the time of his arraignment. It doesn't make any difference that all of his rights attach. He has the right to assistance of counsel from the point that he's arraigned. That doesn't make any difference.
I think it does make a difference, Judge, but he's also entitled to a grand jury proceeding where 12 members decide after participating if it's sufficient to proceed. And he was not given that here. I don't think it leads to an absurd result for a strict reading of this statute when the Commonwealth had the evidence for 10 years and for whatever reason sat on it and missed the deadline for an indictment. I would argue they could have taken out a complaint and still complied with the indictment portion of it if they wanted to, if they behaved differently in this case and not neglected the evidence for 7 years inexplicably and then 3 years after that. They rushed up on the eve of the statute passing and passed a police report to a district court clerk who stamped it and issued a complaint. And the argument is that's distinctly different than a grand jury proceeding, and it fails to meet what is specifically listed in the statute, which is the requirement for this particular crime to have an indictment. And it didn't say or complaint, and I argue that it should not be read interchangeably with complaint throughout the whole chapter. And I think the position of my brother and the questions of the court relative to the catch-all only listing an indictment is an issue worth addressing, but for criminal statutes to be read in the light most favorable to the defendant, I think that's where complaints can be read or inferred into the catch-all provision as capping the amount of time that a prosecution can commence. That's the intent of the entire statute. It's no more complex than that, in my opinion. It's limiting the time in which the Commonwealth or prosecution can commence against an individual to protect their liberties. So if we're going to infer that 79 applies, it's not going to be at the expense of the defendant if it's unclear. It should be read literally, indicted or not within 10 years. And in this case, they did not indict Mr. Perella within 10 years. The motion to dismiss was filed in front of Judge Sanders, who happened to agree in this instance.
Mr. Troy, you may not know this, and I don't, but I'm just going to ask you. In the first sentence of 63, which is, I don't know if you have it there.
I don't, Judge. 1 second.
Sorry, second sentence. An indictment or complaint for an offense, and then a whole bunch of statutes are listed. And my question is, you may well not, this isn't your case, but are those ones that are within the concurrent jurisdiction of the district court and the superior court?
Just like Your Honor, I'm uncertain of that answer,
that's
Judge.
fair enough. I just didn't.
I do recognize, and I did look at the statutes or the particular sections that my brother referenced, and those are all in the exclusive jurisdiction of Superior Court, and that's why I believe they referenced indictment.
Right.
Just so I'm clear as to your argument, let's imagine a larceny over 250, which is a felony, and let's assume that the Commonwealth wishes to proceed in the district court on that case. And they do so 5.5 years before, I'm sorry, 5.5 years after the date of the crime, and then no indictment occurs after 6 years. Dismiss the district court case, or simply say, no, now you can no longer proceed in Superior Court? I'm just trying to figure out how you interpret that provision of the 6 years.
If I understand correctly, Judge, if a complaint is brought in district court.
District court within the 6 years.
Larceny over 250 within 6 years, so it complies with the catch-all.
Well, it doesn't, because there's no indictment.
So 6 years applies to district court complaints as well, Judge, right, for the catch-all?
The catch-all you're referring to is the provision in 63? Or are you referring to a different provision?
No,
The district court statute of limitations.
Which is in 63?
it's reading it in there.
I'm reading it at the end of 63, Judge.
Okay, but you're reading it in the sentence which says an indictment for any other crime.
Yes, Judge.
So there you're reading indictment to include complaint.
I am, Judge, and my previous argument that I made briefly was if there's any ambiguity in the statute and it's to be interpreted in any way, it's to be interpreted in a way that makes sense and is not more harmful to a defendant or more restrictive on the defendant's rights. So if we're going to interpret the statute to avoid an absurd result, which in this case may be no statute of limitations on district court because the word complaint is not included there, I think it should be interpreted to protect the defendant, where it's capped at 6 years, and that's why it's the catch-all.
All right, and would you say if that same larceny of a person case, if the Commonwealth said, no, let's now proceed in Superior Court and were to indict more than 6 years after, that they could no longer do so? They would have to then proceed in district court? Because they had not indicted within 6 years and they're therefore left to the district court jurisdiction?
I think if it's a crime that has concurrent jurisdiction, and the statute affords they also can be indicted within a specific time period. If 6 years is the statute of limitations and the catch-all, and that's all that applies to that crime, and they haven't indicted him within 6 years, I don't believe they could indict him.
But you don't need to go there.
I don't, Judge. I think in this case the facts are very limited. It is, I know my brother cited the Dixon case and a couple of other cases. I think those are distinguishable cases. I think the footnote in Dixon, footnote 20 for Northern Telecom, was a district court case. I think the Dixon case itself was a DNA case where an indictment was taken out
brought, yeah.
in time. It complied with the statute, but it was the argument whether it was specific enough to be fair to the subsequently named and found and located defendant. So I think that's distinguishable as well. They comply with the statute in the time frame required, which is totally different than the case before us, where they didn't indict him in the time frame that the statute specifically requires for this crime. If there were no further questions, sir,
Thank you,
I thank the
counsel.
court. Thank you.